Picture this. You're tearing across a beach in 1805, chasing a wild fox like your entire reputation depends on it. Dogs barking, adrenaline blasting, horses kicking up sand. You're exhausted, but victory is finally in sight. You've been chasing a wild fox for miles. Then out of nowhere, some guy shoots the fox, scoops it up, and walks off like he did all the work, like he's the hero of this story. Do you know that outrageous moment? Now, that moment of pure disrespect, that sting, that's the heart of Pierson versus Post, the case that launched 1,000 property law headaches. And a case we are diving into here at 99 Rights Online, where we turn case law into cheat codes. So let's get into it. Now, Pierson versus Post is one of the most iconic property law cases in American legal history. Also, the case that has taught generations of law students exactly where first possession ends, where custom fails, and why property law sometimes feels like a reality TV feud with horses and hounds. So, meet the players in our case. Post, the guy who chased the fox with hounds, horses, and pure determination. Pierson, the guy who saw the fox, shot it, and said, "Finders keepers, buddy." Post sues Pierson for trespass on the case, claiming Pierson wrongfully interfered with his fox. The trial court sides with Post. Pierson appeals to the New York Supreme Court, and boom, the higher court reverses. Why? Because under the law, a fox is feri naturae, a wild animal that belongs to no one until someone actually captures it. The big question: does chasing a wild animal give you ownership? Or do you have to actually capture, kill, or mortally wound it? Post says, "I pursued it. I had a reasonable chance." Pierson says, "Nah, no take, no title." And the court dove into Roman law, ancient scholars, and old hunting treatises, and decided pursuit alone is not enough. You need actual control. So Pierson wins. Post gets nothing but cardio. Now, Judge Livingston dissented, basically saying, "Come on, custom matters, public policy favors encouraging fox hunting." And finally, Pierson acted like a jerk. But in the end, the court basically said, almost catching something is the same as not catching it at all. And that's how one unlucky fox, two very determined men, and a whole lot of petty energy created the rule of first possession and the foundation of modern property law. It's harsh, it's cold, it's legally correct, and it's why Pierson versus Post still haunts law students every year. This case is the blueprint for the first possession rule. It's the OG almost doesn't count case. This case didn't just settle a fox fight, it set the rules for who owns wild animals, natural resources, found property, and even modern digital assets. Pierson vs. Post is the moment property law said, if you want it, you better actually get it. So the next time someone steals your thunder, your parking spot, or your fox, just remember, Pierson vs. Post walked so the entire capture doctrine could run. Love wild legal stories like this? Hit subscribe and follow at 99 Rights Online, where we turn legendary cases into lessons you'll actually remember. Thanks for watching. Liked this? If you found this information helpful and inspiring, don't keep it to yourself. Share it with your friends and family. And remember, knowledge is power. Stay informed, stay empowered, and keep fighting for what's right. See you next time.